The Supreme Court considers the contraception mandate. More developments with Obamacare, unionized college athletes, and an intra-movement spat. I am Daniel Mushala, and this is The Square Circle. Joining us today are Aaron Matson of RH Reality Check, Democratic strategist Matthews Pearson, Kelsey Osterman of Red Alert Politics, and Akil Aline of Young Voices Advocates. Welcome. The biggest story this week has been the high-profile case at the Supreme Court that pitted women's access to contraception against the religious rights of business owners. The owners of arts and crafts chain Hobby Lobby have petitioned for an exemption from Obamacare's mandate to provide contraception because of the owners' religious beliefs. The government argues that for-profit corporations have no right to restrict their employees' access to birth control. Kelsey Osterman, which party is being wronged?
Unfortunately, I think this is a classic case of the government overreaching its boundaries and trying to enforce something that fundamentally violates the First Amendment. One important thing to remember about this specific instance is that Hobby Lobby is not some massive corporation. They're not ExxonMobil. They are a family-run business, and this family has every right to run their business how they see fit.
Aaron?
Well, that sort of thinking, first of all, is just contrary to the spirit of the law, but also has been firmly rejected. Most recently, we were talking about that same kind of idea in Arizona, whether a business should have a license to discriminate based on what they say are their religious beliefs. And so the question before us, really, I think this is one of the most important Supreme Court cases on women's rights in my lifetime. The contraceptive benefit is something that was put out by was rooted in the Institute of Medicine taking a completely nonpartisan look at what is basic health care, preventive health care. More than 99% of women at some point in their lives use contraception. And so this is an issue about discrimination. If a business doesn't want to provide contraceptive coverage, they don't need to provide insurance coverage at all. They could be paying a $2,000 per employee penalty instead, and they're choosing not to do that. They're trying to take the whole law down with them.
Akil?
Essentially, I think the problem here is that what really should be more about people's ability to run their businesses as they see fit based on any issue of personal belief, whether it's religious in nature or not, is being sort of shoehorned into the context of a religious freedom debate. I think that for a number of reasons, Hobby Lobby and other companies like it should not be forced to provide birth control or any number of other services through their insurance policies. Frankly, first off the bat, I think that this country actually needs to move away from the system of employer-based health insurance, which has a lot of flaws in it, and I think is at the root of a lot of the problems with American healthcare generally. In addition to all the practical flaws in that system, you have the principal factor that I don't think it's employers' job to ensure that their employees are actually able to access healthcare and other things of that nature. I think that, if anything, it would make more sense, or it would be less objectionable at least, for the government to subsidize women's purchase of birth control in this case, than it would be for the government to force employers to provide it. When it comes to the religious freedom issue, the problem I have with that is that I don't see why a person who has beliefs based on religion should be exempted, especially as a judicial matter, from having to comply with a law like the contraception mandate, whereas someone else who may also run a business may also want may not want to have to cover the same healthcare treatment in the insurance policy for a different reason, a non-religious reason, would not benefit from that legal shield. And so, while I'm sympathetic to the idea that the government is overstepping its bounds in this case, I don't think that religion per se is the main reason why.
Well, if we think that the government is overstepping its bounds in this case, then you think that the government is overstepping its bounds, as Aaron said, in the case with Arizona. If religion or any of these other moral considerations allow businesses to change the services they offer or to their employees or the customers they serve, then we're throwing out the whole Civil Rights Act, the American with Disabilities Act. Those are important things we've all come to accept and understand that businesses do better, America does better with these things. They're not discriminating on the business owners, they're helping everyone get a fair shake. And the idea that using a religious exemption to get out of birth control for this is, somehow harming, not using a religious exemption, if that's struck down, it's harming the business, and it's a family business. If it's such a family business, as you said, it's a small business, then they would have their family working there. And I would have no problem with mother and father, in their little restaurant saying to their daughter and their son, you can't have contraceptives that we're going to pay for. But these are employees that they have, and for them to be able to choose their health care services, they could say to me then, we're not going to provide for you if you have a heart attack, because we're Christian scientists and we don't believe modern medicine should heal you. I think we can all agree that's overstepping its bounds.
Yeah, but you still have the option of finding the medical treatments through other means, right? It's not as if... One of the things about this debate that I think is very inaccurate, I think it's a big misconception in the debate over these kinds of mandates, is this idea that an employer that denies insurance coverage for a certain healthcare policy to its employees is stopping its employees from accessing that form of healthcare, or that it's violating their rights in some way, or imposing its beliefs on them. I actually reject that view firmly. The problem is, if you were to say that I have a right to access birth control, that's one thing. That means, in my view, that you should be free to use it, to access it and use it if you so choose, as well as not to use it if you don't want to. Sure. But it doesn't mean that others are obligated to pay for you to get it. Now, again, like I said earlier, this is part of the reason why I think it would be preferable, if anything, and not sort of heretical for a libertarian to say this, but I think it would be more respectful of individual freedom if, the government were to subsidize the purchase of birth control and other needed healthcare treatments directly. But to force employers to provide it is to say that doesn't concern a right; it's an entitlement.
This is just incorrect, because first of all, there's no religious freedom real problem here, because it's not like the family is being forced to take and use contraceptives. It's not like the store. We haven't even talked about this idea that a corporation can have a conscience, a for-profit corporation, which I reject that idea, and let's hope the Supreme Court does as well. But it's not like the store is being forced to take contraceptives either. And in fact, it is a substantial burden on employees to have access to contraceptives curtailed, because when you're talking about the average cost that goes out to people. So for example, let's make this personal. When I was a student at Georgetown University and I was on the student health plan, it cost $110 to fill my birth control prescription because it was not covered. That is what the Greens want to do to their employees through the Greens being the Hobby Lobby family, what they want to do to their employees by taking away contraceptive coverage. That is flat out discrimination. Now, some people will say things like, well then you don't need contraceptives, or you can choose not to have sex. I think that's a ridiculous argument, period. But the fact is, there was recently a case at Georgetown University as well, another student who was not able to afford her contraceptives, and therefore that she was taking for a syndrome that she had, she wound up having to have an ovary removed. So this is a really serious thing, to remove contraceptive coverage from women. It's really a case about women's rights and anti-discrimination under the law. And so we're not talking about a case about birth control simply. We're talking about women.
All right. I'd like to remind our audience that you could submit your questions to our guest through our website, www.publicsquare.net, and we'll answer as many as we can live on the air towards the end of the show. Now, staying on the subject of Obamacare, This week, the administration issued yet another delay, this time extending the March 31st deadline to sign up on the exchanges to mid-April. However, it also came out this week that more than 6 million people have signed up, which seemed to put to rest the claim that no one would enroll. Aaron Matson, what do these numbers mean to you?
Well, it's good that people are getting more access to health insurance under this law. That's something to applaud. It's a start, okay? No one's going to say that the implementation of the law hasn't been rocky. However, we've seen different results coming out of different states depending on what kind of supports are in place to help people enroll. One thing that I think is really important numbers-wise to watch going forward is about half the number that have signed up through the exchanges have also gained access to Medicaid through Medicaid expansion in half the states. And that's an ongoing battle to watch in terms of which states will continue to allow people with lower incomes to enjoy funds that have already been set aside by the federal government to pay for health care.
Kelsey?
You know, I think one point about this figure of 6 million people who are now covered under Obamacare is that, yes, you have 6 million people who are now covered under the law new, but what about the people who have been dropped from their health coverage because of this law going into effect? An Associated Press survey recently said that only 26% of Americans approve of Obamacare, and when the law was passed, that number was 41%. So you can see this downward trajectory of the number of Americans who just don't see this as a good thing. And I think the numbers balance between the people who have gained coverage and the people who have lost coverage is part of the reason why.
Matthews?
I think the story of people losing coverage is overblown. This 6 million, we don't know exactly how those numbers are going to play out. And part of it's Medicaid expansion, and some of these people may be getting new plans. Some of these people in the 6 million are probably those who lost coverage, but gained new, better coverage, probably at around the same price. People who were very upset about losing their coverage and said, I was supposed to keep my coverage. Many, when they actually read the plans, someone went over it with them, found out that they were capped for catastrophic care. They were in a big accident or had cancer. They were going to have a lot of problems. And so they may have lost their coverage, but it wasn't much coverage to start out with. And it was very regrettable that people lost coverage and that people thought that they were going to be able to keep any coverage they have. And I think that was a mistake, and it's been learned from. But the law has had steadily declining numbers, but not that much that is really going to help people has gone into effect. Now we have these 6 million or so people, and it's a late surge. I think the final numbers with a couple of days to go really could be much higher. As those people get their coverage, as they get to a doctor, if they get sick and then find out that they're not capped and that their prescription drugs are cheaper, I think that we're really going to see a lot higher approval of the law through the summer and into the fall. And this is the first year. We all need to remember that. As people see it work this year, as people talk to their friend down the street who got coverage, when we hit an open enrollment again, I think the numbers are really going to jump.
Okay.
Well, I've never thought that the sheer number of people who've signed up by a certain point in time was that dispositive. I don't think it's actually wise to get too hung up on these particular numbers. People are saying, this puts to rest the claim that no one would enroll. Anyone who claimed that no one would enroll in, a program like this, would sign up for coverage, was really just speaking very rashly. It was always going to be the case that a number of people, whatever number, were going to try to take advantage of whatever opportunities the law presented. I think the bigger picture is whether this type of law is the best kind of healthcare reform for the country, whether it does enough to control healthcare costs, to expand access to healthcare without hobbling, the kind of competition between healthcare providers and health insurers that would actually help bring down costs. Based on everything I've read, I'm not an economist or a healthcare specialist, but based on what I've read coming from both sides, I think the law is flawed in a lot of other ways. And I think that being too hung up on the question of how many people have enrolled so far diverts our attention from from the bigger picture, a lot of the flaws in the law that haven't been addressed.
Last word?
Well, let's not let the perfect be the enemy of the good. And this law is an important step toward moving toward greater access to healthcare for everyone.
All right. Another story this week is that Northwestern University football players convinced the National Labor Relations Board, that they are employees of the school and therefore have the right to unionize. Not everyone is celebrating, though. Some warn that the decision will forever alter the relationship between universities and the student athletes who represent them. Matthews Pearson, was this the right decision, and what does it mean for college sports going forward?
I absolutely think it was the right decision. These student athletes, especially with the big football factory schools and the big basketball programs, are much more athlete than student these days. And for them to be able to negotiate collectively as a union, I think can really help these student athletes. But that aside, and everybody's hyperventilating now, we are years and years from even the possibility of unionizing. So I think that people right now talking about the universities having problems having to pay their players, and it's going to change the way college sports are, and the academia and the meaning of student athlete, need to just take a moment and see how things play out. That said, I think that this will, as I said, help the players. I think they'll be able to negotiate for health care. As a quarterback from Northwestern who's been spearheading this said, his main thrust is players to get health care. And these players are putting their bodies at risk every weekend, every day in practice. And many of them get an injury and are just thrown aside by the school. And I don't think most people realize that scholarships are only a year-to-year thing for most major programs. In fact, almost all programs for almost all sports. And a young player comes in and he injures his knee and he thought he was going to college. And the coach comes to him and says, "Hey, I'm sorry, but you need to pack your things because we don't have a spot for you next year." And I think when we're talking about this unionization, that's really what we're talking about. We're talking about a fair shake for the players. The vast majority of players are never going to be paid. They won't make much money if there was payment. So I think it's getting these kids an education, ensuring that they receive that education no matter what happens to their body as they make millions of dollars for the school.
Akil?
I think that if employees want to form a union, they should be free to do so. I suppose the first thing that jumped out at me when this issue was brought to my attention was the NLRB's classification of the student athletes as employees. Let me say up front, I'm not a big sports fan at all, and so I'm really, you're asking the wrong wannabe pundit for his first take on this particular issue. But I was always under we know for a fact that currently the student athletes, they're amateurs, they're not supposed to be paid in the traditional sense. But the NLRB has ruled that, the scholarships function, for all intents and purposes as remuneration. I mean, the lawyer in me is willing to quibble with that, but at the end of the day, if the students themselves see fit to join forces and increase their bargaining power by acting as a unit, as long as they're not being forced into it against their will or prevented from doing it against their will, go with God.
Aaron?
I think this is fascinating because unpaid labor is such a huge part of the college experience right now. It's not just looking at sports teams, and I think that's a really interesting discussion that we've been having. But if you look at the rise of the unpaid internship and this expectation that young people, in particular, it actually disproportionately impacts women taking these unpaid internships, should work for free, and yet they're not being treated as employees. It's really interesting to think about the NLRB really recognizing student athletes as employees even though they're not getting paid. And so I do think this is an interesting ruling that gives us lots to think about in other realms as well.
All right. Kelsey?
I think most people would agree that there's way too much emphasis put on the athlete part of a student athlete, while ignoring the obvious fact that these students are there to get an education. And just like a student who may have an academic scholarship, yes, they're there on a scholarship basis, based on some qualifications they had coming into the school. But I don't think that student athletes should be, really treated any differently from any other student who is, quote unquote, getting paid by the university through a scholarship, a full ride scholarship. And because Aaron brought it up, the issue of the unpaid internship, I think unfortunately, as we push for more paid internships only, and then you'll see these rise of the number of lawsuits against employers who are offering unpaid internships, you're going to actually see the entire death of the internship. Because frankly, most interns' work is not worth paying them minimum wage because they don't know what they're doing. They're there to learn. So I think that these interns are unfortunately going to miss out on valuable experience if we demand that all of these internships be paid.
Now, it's interesting. The argument specifically from the athletes is that they perform, and out of their performance generates a lot of income for the universities. So shouldn't they get paid for their performance?
Well, I think that there's this idea that, and everybody throws around this idea of pay for the athletes, and there are these star athletes. There's the Johnny Manziels, and
let's be specific about this. That the fact that the athletes, especially basketball and football specifically, generate more income than those who are on the swim team and other teams.
And that's one of the big arguments against paying athletes is if you're paying Jadeveon Clowney several $1 million a year, then the school's got to get rid of their swim team. And I don't think that I go as far as paying the athletes for their, because all these, if we're doing that, and there's a very small number of these athletes who have the name recognition and what star power, I guess is the way you would put it. But the offensive lineman, the inside linebacker that no one knows the name of, they shouldn't risk their scholarship. And so I think not as a matter of policy, but as a matter of what the student athletes should be working for, they should be wary of working towards pay for student athletes. I think they'll find that it backfires. But things like medical coverage and assured scholarships are probably very smart for them to do.
All right. Have a word on that?
I guess I just wonder whether there might be, in the very long run, mind you, some alternative means of giving, student athletes a better shot. I mean, aside from the question of unionization, I mean, part of the reason why the universities, and this is just a hunch I have, I'm not an expert on the subject, but I get the impression that the universities are able to get away with not paying student athletes anything because so many young athletes, especially those who hope to go pro someday, want to play these sports so badly. And the system that's set up right now has been functioning the way it's been functioning for a long time. Everyone's used to it. There's a lot of inertia. And so, the universities are in a better bargaining position. I don't know whether it's possible, to see the emergence of some alternative league for, athletes who haven't made it to the pros yet, but a league that's still not directly tied to the universities that may be willing to pay them something. If these young athletes had some other options available to them, options that might pay them something, that might put more pressure on the universities to give them a better deal. It would basically represent competition in the market for young athlete services.
Wonderful. Finally, there was a bit of a spat within the libertarian movement this week. Presidential candidate Ron Paul made remarks about Russia's recent invasion of Crimea. I'm messing up today. I'm just fumbling around myself. That ruffled the feathers of the libertarian group Students for Liberty. Ron Paul's camp fired back, resulting in sore feelings all around. Akil, could you explain the dispute and where you come down on this issue?
Let me just say, if this is your idea of a spat within the libertarian movement, then the liberty movement is in a perpetual state of civil war 24/7. We have plenty of internal disagreements within our ranks, disagreements between employees of different organizations, members of different student groups like Students for Liberty, and so on. Now, what happened in this case was that some members of Students for Liberty published an article criticizing Ron Paul's stance because they felt it came across as, I guess, a bit too soft on a moral level, at least, on what I agree is Vladimir Putin's aggression in Crimea. Their point was not that the United States has the responsibility to police the world or to discipline every foreign actor that commits some injustice outside of his own borders. The point, frankly, one of the things that the article emphasized was that war in Crimea is not an option for the United States or for the international community, that excessively coercive intervention is not really an option for any number of reasons. The issue was too many people in the liberty movement, and this is a sentiment that I share, have criticized or have responded to the crisis in Crimea by condemning the United States for condemning Putin's action, as if the United States is the only government that ever abuses its power on the world stage, the only government that ever intervenes where it shouldn't, the only government that ever shows a lack of respect for other countries' sovereignty, right? My position is, and I think that the gentleman who wrote that article would agree, there is a lot of daylight between, on the one hand, excusing what Putin has done or making excuses for it, and on the other hand, calling for the United States to go charging him with guns blazing to try to set the situation right. There's a middle ground here. If there are any steps that Washington can take to try to encourage Putin to behave himself in Eastern Europe and respect the sovereignty of the countries around him, around Russia, that's not too coercive, that won't lead to a wider conflict, then the U.S. arguably should take those steps. Even if it shouldn't. Even if there's nothing the U.S. can do, that's still not a reason for us to, let Putin off the hook. What he's done here is very wrong, and our libertarian convictions shouldn't stop us from noting that.
Aaron?
Well, I was flabbergasted to read this denunciation from the Ron Paul Institute representative writing back to this president of the club. I mean, it really is condescending, just dripping with condescension on the basis of age. I'm sorry, you might not understand something like this. And it just, it is something that I think, brings to light broader questions about the libertarian movement, which is, often represented as kind of this hipper, younger republicanism and conservatism, and there's still just total jerk-like behavior toward young people. And can this sort of thing continue? I'm certainly not in the movement, so I'm interested to hear what Akil has to say.
Akil?
Well, condescension towards young people? I mean, I've spent a few years in the movement myself. I haven't encountered that kind of condescension, but then again, I haven't done any work with the Ron Paul campaign or with any other organization affiliated with Ron Paul. The thing to remember is he's only one libertarian. One of the challenges that the movement faces right now is that there are still only a handful of self-described libertarian public figures out there right now whom your average citizen could even name. And so whenever someone like Ron Paul or people who work for him take an action like this, a lot of observers make the mistake of attributing those views and those attitudes to the whole liberty movement. Let me take this opportunity to disabuse everyone watching of that notion. Ron Paul does not speak for all of us. The movement is anything but monolithic. And one of the things I'd like to do in the years to come is help bring more and more libertarian, especially young libertarian voices to the table, if only so that folks know that we're not all so full of condescension or contempt for young people or what have you. And that's why I'm here, frankly.
Wonderful. Kelsey?
As far as condescension towards young people goes, I don't know if you've seen the Obamacare ads that are being foisted on young people, brochurins. I mean, come on, can you get any more patronizing? But in regard to this specific issue, I think this group had every right to call out Ron Paul for what he was saying, and I encourage this sort of dialogue. I would agree that it came off a little condescending, and that's something that every movement needs to work on, is making sure that inter-movement dialogues are constructive and accomplish something in the end.
I would agree with that last point of yours, Kelsey, that yes, this was condescending, but to talk about the whole movement having a problem and this is this big spat. Every organized political party has these problems, and young operatives or young activists being put in their place, maybe not as publicly and maybe not as the way this was done, but it happens everywhere. It happens with Republicans, it happens with Democrats. I'm sure the Greens, wherever they are having the same problems too. So this is any organized or disorganized party that we're all a part of has these growing pains, and each time you have a new generation, you should welcome these spats. This is what makes a group stronger. The Republicans are fighting their way out of the 2012 loss, and they're figuring things out. The Democrats had their dark days where they fought each other. They're still fighting each other, and it's a healthy dialogue. It's going to happen in public. It's going to look bad for a couple of days or a week, but it's best for the movement unless it gets to a true civil war and groups breaking away.
Okay, let's take some questions from our viewers. And the first question is open to anyone on the panel. If your argument is that businesses do not have religious rights because they don't pray to God, couldn't you say the same thing about religious hospitals and universities? And this is from Irving Powers.
I'd be happy to take that just in the context of the law that we're talking about. There actually already is an exemption for religious institutions are not required to comply with the contraceptive mandate. They can go out. Religiously affiliated institutions are able to opt out by having actually the government stepping in and covering the costs. And so that hypothetical situation describes something that we don't need to worry about because that's already been taken care of.
I think with the one thing that the questioner specifically was asking is, what is the difference between these nonprofits who are religiously motivated and a religiously motivated for-profit corporation? And it's simple that the religious nonprofits are motivated by religion, and their goal is the religious outcomes or the religious acts involved. A religious hospital is caring for people because that's what they believe they're supposed to do, and they're not. That's the whole thing they're in it for. A for-profit corporation may have some religious ideals, or their owners may have some very important views on religion, very deeply held convictions, but a for-profit corporation is for profit, not for religion. So that's really the difference. It's very simple.
Akil?
I'd like to push back just a little bit in the sense that, it's entirely possible, even for a for-profit corporation, to have principled beliefs that it seeks to advance through its operations, whether they're religious in nature or not. I mean, we have examples of other corporations, such as Whole Foods. I forget the name of the company that brews Fat Tire, which is one of my favorite beers. These are corporations that also seek to advance certain, philosophical beliefs about the relationship between human beings and their environment, and other sincerely held convictions of that nature. I don't think it makes sense for the government to force businesses to operate in a way that contradicts their beliefs, if it's possible, to craft a public policy that that doesn't go down that road. Now, my problem in this case is that you have religious motives specifically being given exemptions rather than other convictions that may be held just as fervently. So for Whole Foods' belief in vegetarianism or environmentalism or what have you wouldn't benefit from the same protection as Hobby Lobby's Christian principles. But and I think that's a problem. But I do think it makes sense for individuals to be able to join together voluntarily in the form of business corporations or any other organizations and run those organizations in a way that is consistent with their beliefs.
Kelsey?
I think oddly enough in this situation, First Lady Michelle Obama had one of the best pieces of wisdom that was not said in reference to this, but totally applies to this. She said our faith journey is not just what happens in church or our place of worship on Sunday. It's what we do Monday through Saturday. And I think that telling someone just because you go into for-profit business means that you have to keep your religion private, you can do it in your own home, but you can't do it in the public sector, I think that's absolutely ridiculous.
But give me a break here. I mean, we're talking about religious beliefs are the exercise of a business owner's religious beliefs are impacted by the private actions of an employee, and particularly we're talking about discrimination. I mean, that's the impact of refusing to cover contraceptives is in effect discrimination against women by saying that you will not cover their preventive health care.
All right, let's go on to the next question here. This is from Angela Graves. Once again, this is open to the panel. Do you think all college athletes are employees, or are there distinctions to be made? So, do you think all college athletes are employees, or are there distinctions to be made?
Well, the National Labor Relations Board, I'll let them handle that, and they seem to have handled it. I think that all college athletes, whether they're big-time football players or basketball players or a swimmer or a lacrosse player, should have the same rights. So if the National Labor Relations Board is ruled as we all think of about big-time football and basketball, I think it's anyone down to the swimmer or the field hockey player should also be allowed to consider unionizing. And then, as Akil said, we're not forcing anybody to unionize, and that would be terrible if someone's forced to unionize or forced to not unionize. But anyone, no matter what they are as a college athlete, should have this right.
Okay, so now it's time for your most underreported story of the week. Kelsey?
Something that got surprisingly little play this week was the fact that the University of Michigan allowed a display to be put up, an art display, basically celebrating abortion as a life-sustaining act. And this program that put this display up